The Supreme Court chamber grew so still, it felt like even the air had paused. Justice Amy Coney Barrett slowly leaned forward, her eyes locked, sharp and unwavering, on former Florida Attorney General Pam Bondi, who stood poised at the podium below. What had begun as a fairly routine session of oral arguments in a vital constitutional showdown had, in an instant, turned into something far more intense, a confrontation no one in the room had expected. Justice Barrett, typically composed and reserved, known for her calm, methodical demeanor on the bench, seemed to shed that restraint in a heartbeat. "Miss Bondi," she began, her voice cutting clean through the silence like a blade, echoing across the hushed courtroom, "your constitutional argument is in direct contradiction to precedent established in at least 3 major Supreme Court rulings. Perhaps, before bringing forward such claims, you'd benefit from reviewing Harrington v. Davis." That tone, curt, dismissive, borderline scolding, caught the attention of every justice in the room. A few subtle shifts in posture from her colleagues revealed that Barrett's pointed tone hadn't gone unnoticed. Bondi, representing a coalition of states in this incredibly high-stakes federalism dispute, froze for a moment, just a breath, as if weighing whether to absorb the blow or push back. But Barrett wasn't done. Her critique grew sharper. "And in addition," she continued, her tone unmistakably incredulous, "your take on Article 3 jurisdiction strikes me as fundamentally flawed. How do you reconcile this with your own past legal writings?" It was the kind of moment that freezes time in a courtroom, a public dismantling by a justice of Bondi's entire foundation. Gasps weren't heard, but they were certainly felt. Yet what came next no one, not even Barrett herself, could have seen coming. With almost surgical calm, Bondi responded, not with defensive bluster, but with a measured, brilliant counterpoint. What unfolded was a legal rebuttal so surgically crafted, so precise. It didn't just answer Barrett's doubts. It caused her to visibly pause, to reevaluate everything she thought she knew about the woman before her. But before we dive deeper into this electric moment, this legal chess match that's now the talk of DC, go ahead and smash that like button and subscribe to our channel for more gripping analysis from the front lines of America's legal drama. Justice Barrett, of course, hadn't arrived at the bench by accident. She had carved her path to the nation's highest court with an impressive mix of intellectual brilliance, deep-rooted conservative principles, and a reputation for razor-sharp judicial questioning. Appointed in October 2020, after a distinguished academic career at Notre Dame and a judgeship on the Seventh Circuit, she had rapidly become one of the most watched and often admired jurists on the bench. Her style? Textualist. Her impact? Undeniable. Even ideological opponents admitted she came to arguments not just prepared, but armed with an encyclopedic grasp of constitutional doctrine. Pam Bondi's background, however, couldn't have been more different. As Florida's first female attorney general, serving from 2011 to 2019, Bondi had built her name on tough prosecutions and political tenacity rather than academic legal prestige. After her public service, she had split her time between private law practice and strategic political consulting. She had tackled some high-profile matters, but standing before the Supreme Court? That was rare. And some critics weren't shy about saying it showed. So, when she was named lead counsel in this pivotal federalism case, eyebrows were raised, a lot of them. Could she really handle the intense constitutional complexity this litigation demanded? The case at hand, Federation of States versus Department of Commerce, wasn't just any dispute. At stake was whether sweeping new federal regulations had breached the constitutional line, trampling on states' rights in areas like taxation and land management. The consequences? Massive. The ruling could reset the power dynamic between state governments and federal authority for generations. For Barrett, this was more than just another case. It was a prime opportunity to reaffirm her originalist approach at a time when the conservative wing of the court was increasingly willing to revisit, and in some cases, reverse, long-standing precedent. She had studied federalism in depth, had written and spoken extensively about it. This case had the potential to be a legacy-defining decision. Bondi, meanwhile, came at it from a lived experience, Her time in Florida's highest legal office gave her firsthand insight into the impact of federal regulations on local governance. And while she may have lacked Barrett's academic background, she had something else: relentless preparation and a deep understanding of the political and legal stakes. She knew there were skeptics. She knew the whispers. So, she had spent months preparing for this exact moment, anticipating questions, fine-tuning responses, and building a constitutional argument brick by brick. And for a while, everything proceeded as expected, until Barrett fired her challenge. Observers knew instantly, this wasn't just a line of questioning. This was a test, a defining moment, one that could make or break the case and Bondi's future credibility before the High Court. Barrett's early, unflinching attack made one thing clear. She believed Bondi's argument had serious flaws, and she wasn't going to wait until later in the session to expose them. But what Barrett didn't realize, what no one did, was that Bondi had more than just surface-level answers. Beneath her composed exterior was a deep well of legal insight just waiting to be unleashed. "Thank you for that question, Justice Barrett," Bondi said evenly, her voice unwavering despite the heat of the moment. Instead of retreating or deflecting, she coolly shifted her notes, taking a breath. "I'm actually very familiar with Harrington. And if I may, I'd like to explain why it supports our position, rather than contradicts it." Barrett raised an eyebrow, not dismissively, but with a flicker of curiosity.
"Please proceed," she said.
Bondi dove in. "The core of Harrington's holding relies on a particular reading of the Commerce Clause, one that Chief Justice Reynolds clearly limited to situations where the federal regulatory interest overwhelmingly outweighs state sovereignty concerns." She didn't glance at notes. She didn't stumble. She quoted the opinion verbatim. And, she continued, what many overlook is Justice Kavanaugh's controlling concurrence, which articulated a precise three-part test for evaluating such cases. Barrett leaned forward slightly, now clearly engaged. Bondi moved on with seamless confidence. In Harrington, the regulation passed all three tests, especially the third, which demands that any federal action be narrowly tailored to avoid imposing excessive administrative burdens on state systems. In contrast, the regulation we're challenging here fails that standard entirely. Then, almost effortlessly, Bondi pivoted to a less familiar case. That principle was further solidified in Westmoreland v. United States, a 10th Circuit case, where the court struck down federal regulations that ignored this requirement, even when there was a valid federal interest. Justice Sotomayor interjected, leaning forward. "Counsel, Westmoreland isn't Supreme Court precedent." "That's true, Justice Sotomayor," Bondi replied smoothly, without missing a beat. "However, this court favorably cited Westmoreland's reasoning in footnote 23 of Montgomery v. Louisiana, especially when discussing the limits of federal power in traditionally state-controlled areas." Barrett's expression shifted, a subtle but unmistakable flicker of surprise. She hadn't expected this level of detail, not from Bondi. But Bondi was far from finished. "And on the matter of Article 3 jurisdiction," she said, building momentum, "I'd respectfully point to a passage from Justice Scalia's dissent in Williamson County. While not the majority opinion, that reasoning on jurisdictional boundaries was later adopted by this court in Nick v. Township of Scott, effectively overruling the prior standard." Barrett cut in again, but this time, her tone had shifted from skeptical to intrigued. "Are you suggesting that Nick's ruling on property rights carries over into the broader federalism issues we're considering today?" "Yes, Justice Barrett," Bondi replied confidently, but not merely as analogy. Through a string of subsequent decisions, lower courts have gradually expanded Nick's rationale, extending its reach beyond just property rights into broader jurisdictional applications. At this point, the courtroom had completely transformed. What started as an attempted takedown had turned into a genuine, cerebral exchange between two of the courtroom's sharpest minds. Other justices began chiming in, Justice Thomas, Justice Kagan, asking complex follow-ups. Bondi handled each one with crisp, articulate precision. When Justice Alito raised a potential conflict with Texas v. Johnson, Bondi didn't flinch. She cited distinctions so specific, so intricately tied to precedent, that several justices were seen flipping through their notes to verify what she'd just said. Finally, Barrett returned to their exchange, but her tone now was markedly different. "Miss Bondi," she said thoughtfully, "your interpretation of these precedents is certainly creative. However, I worry that accepting your view would require us to significantly narrow our holding in Denison, which has been our guiding framework for nearly a decade." It was a complex, surgical concern, the kind that would have unnerved any less prepared attorney.
But Bondi?
She was ready. "Justice Barrett," she said with clear respect, "I hold Denison in the highest regard. I believe, however, that applying it here doesn't require narrowing it. Instead, it calls for recognizing its natural limitations.